Do you ever get to wonder how long divorce takes? Right, so this video is for you. In case you're wondering how long will divorce take in Nigeria, just in case you wanted to file divorce or someone who is close to you wants to file one and you need to answer them. My name is Earl and I'm alright. I am a family law lawyer and also a counseling psychologist. However, what I share here is not professional advice. It's just for educational and orientational purposes. I want to say thank you for joining me on this live, and I'm doing this from the city of Ibadan, Nigeria. So in the comment section, I would like to know where you are joining me from. Right, so let's go straight to today's conversation and today's discussion, which happens to be how long does divorce take in Nigeria? I'm choosing to answer this question today, although I've answered this several times on your family lawyer, but I'm answering it again because I have noticed that from time to time people get to have this worry, people get to have this concern. Many people want to walk out from their marriages, many people want to divorce, but they don't know what to expect. They don't know how long it's going to take to determine when they will start. We've seen many people who want to start their divorce the moment they have already relocated, and we have relocated out of Nigeria. And there are many times we've also seen people who usually want to file their divorce just about few months to their wedding. Perhaps they have been separated from their partner for a long time or for a short period, and right now they are already in another romantic affair that is leading to marriage, and so they wait till like a month to their wedding. Sometimes they do want to file for divorce after they have even done introduction and with their new partner. Well, we'll come to the legality of that on another day, but today's focus is how long does divorce take in Nigeria? I wish I could tell you a fixed time that, oh, divorce in Nigeria takes 3 months or it takes 3 years. However, there are many factors that determine how long divorce takes in Nigeria. And today I'll be sharing with you these factors, and you will see which of them applies to you, applies to your marriage, or that of your friends. Let me say this to you. Now you're speaking with a lawyer and you're speaking with a family lawyer. I know this is not professional advice, but I want you to pay more attention and take what I'm sharing here to build the proper education on the matter. I know you've seen movies, you've seen skits and the rest, and sometimes we lawyers, when we see those skits, we laugh. At the time of making this video, I was already 13 years post-call. Yes, so as of today that we're enjoying this life together, and I'm doing this live from my study here in the city of Ibadan, I'm already 13 years post-call. So I'm bringing you what I have seen, what I have observed, what I have read, what I know about our legal system and our court system over this period, in addition to the years I spent studying law in the university and also being at the Nigeria Law School. Now, the first things you need to realize when it comes to divorce in Nigeria is that we have 2 types of marriages. You must understand that. We have the traditional marriage and we have the statutory marriage. When it comes to traditional marriage, we have 2 types of marriages that are grouped under traditional marriage, the big umbrella of traditional marriage. The first one is we have every marriage that is based on the different tribes and customs in this country. So it is based, once a marriage is based on your tribal customs, is based on the customs of your wife, then we say that is a traditional marriage. Yes, when it comes to traditional marriage, the law that actually applies is the tradition of the woman. Most of the time, it is the tradition of the woman. The reason why it is the tradition of the woman is because you married her based on her tradition, not based on your tradition. So she was married based on her tradition. So if you're going to be divorcing her, the proper thing to do would be to divorce her based on her tradition, because it is that custom that would, to a large extent, determine if she is still married or not. However, the law has made it easy, very easy, and that's it, that today if you are married under customary law, for you to be validly divorced, for you to be legally divorced, you have to contract that divorce in a customary court. Right. Now, you must not go back to her village or to her state to do the divorce. You can actually do that customary divorce in any other Nigeria state where the two of you are living, or most especially where she is living. And the court, the customary court, will always take into consideration what her custom says, right, in finalizing that divorce. So we have traditional marriages that are based on the respective customs in Nigeria, right? And in this particular case, the custom of the woman. And we also have Islamic marriage. I know people will say, oh, Islamic marriage should stand on its own. I actually wish Islamic marriage could stand on its own. But when you look at the elements of an Islamic marriage, and you look at the tenets of an Islamic marriage, and you look at what is required to make an Islamic marriage valid, vis-a-vis what is required to make a customary law marriage valid, or rather a traditional marriage valid under the different customs in Nigeria, you notice that they share similarity. The first major similarity they share is that consent at all times is required of the guest parents for marriage. At all times, no matter her age. Another thing you will also realize is that under all the various customary laws in Nigeria, and also under Islamic marriages, you can have more than one wife. A man can marry more than one wife. So in family law, customary marriages and Islamic marriages are all grouped together as traditional marriage. They are all grouped together as customary marriage, right? Then after you have noted that difference, you should realize that there is another type of marriage. Remember, I mentioned two. So we have customary marriage, which has to do with all the traditional marriages, right? Depending on your Islamic religion or your tribe. Then we have statutory marriage. Statutory marriage is based on the Marriage Act. It is called statutory marriage because it is we have a legislature. It has been codified. It's now a statute. It is a law that everyone can access. If I could reach close now, my Marriage Act is on my shelf and it's a bit far. If it was close to me, I would have shown it to you, right? So now it is codified. So it means that it is a written law. It is a written law that is of the National Assembly. We have one Federal Marriage Act. So it means that if you say you are married under statutory law in Nigeria, we are all governed by the same act. Nigeria is one. When it comes to customary law, we are looking at, your religion, or we are looking at your tribe. But when it comes to statutory law, we are looking at one law, every one of us in Nigeria. And that's why when it comes to statutory marriages under the Act, you could actually contract the divorce. You could file for divorce and get a divorce anywhere in the country, as long as it is a federal high court or a state high court. But let's come back to the two types of marriage, the customary marriage and the statutory marriage. Now, the statutory marriage is any marriage that is based on the Marriage Act. Now, for a marriage to be based on the Marriage Act, it means that you must have contracted it in two primary places, or rather, let's say three places. The first place, and most common that most people know, is at the marriage registry. And we just simply call it in Nigeria court marriage. Well, it is not court marriage. I understand you call it court marriage because you feel that that particular marriage registry and the way it is conducted is like a court proceeding. But in reality, it has nothing to do with the court. It's a marriage registry. And I understand the reason why you may call it court marriage is also because it is based on a law. But it is actually called statutory marriage conducted in a marriage registry. You can either conduct it in a marriage registry, or you can conduct it in a church, in a licensed place of worship, right? a church that is licensed for marriage. Another place where you can conduct it is that you can conduct it in any other place that is licensed by the governor. So if the governor licenses a garden, if he licenses a hall, yes, if he licenses a mosque for that marriage, you can conduct the marriage there. The rule always says that whenever you are conducting the marriage, you must follow the rules of the law. You cannot use your own preferences. You have to follow what the law says. Now, we have these two types of marriage. So the type of marriage you have will determine the type of divorce you will have. And this, again, will to a large extent determine how long your divorce will last. So now that we have, first of all, understood that we have the differences in the types of marriage, we'll go into them one after the other. First, the statutory marriage is governed by formal laws, right? While the customary marriage is governed by the customs and also governed by the Islamic religious beliefs, principles, and tenets. Now, one primary thing that will determine how long your divorce case will last in court and how long that divorce will last in court, if it's that of a family member or a friend, is the grounds for the divorce. There are several grounds for divorce. There are several reasons why a person can come up and say, oh, I want to have a divorce. Now, the grounds for the divorce will determine how fast that divorce will be. Let's take, for example, I'm going to be focusing on statutory marriage, for example, right, which you can only do the divorce in a federal high court or in a state high court. And the good thing is that you can do it in any federal high court or state high court in Nigeria. Now, let's look at these two grounds. For example, one person comes up and says, I want to divorce my spouse. I want to divorce my spouse because we have been separated for 2 years, or rather we have been separated for 3 years, because there are two types of separation. If you have been separated for 2 years, you can come up and say, oh, I want to divorce. It is what we just generally say out there as no fault divorce, right? If you come up and say, oh, we have been separated for 2 years, so I want to divorce, yes, you can divorce. However, if your spouse comes to oppose that divorce, the court will consider your spouse's request for the marriage to still continue. The court will consider it. However, if you have been separated for 3 years and above, your spouse cannot even contest it, right? So the court would have to agree with you. When you're in court, the only thing you have to prove in this situation is that we have been separated for 3 years. That's only what you have to prove. You just have to show in court that we have been separated for 3 years or we have been separated for 2 years, depending on which particular reason you want to show, right? Once you can show that to the court, and you can show that in the court on the same day to show that you guys have not been living together, you guys have not had sex in the last 2 years. And once the court agree with you, that's fine. So it is easy. What if in a situation where your grounds for divorce is adultery? The law says that the adulterous person, right, the partner, the person with whom your spouse committed that adultery, has to be joined to the suit. So right now, you are not just always suing your partner, your spouse, you are also suing the adulterous partner of your spouse. So you see, this will make your case more cumbersome, right? The requirements to prove the adultery becomes more cumbersome, and it may take time for the court to go through all that process. Now, it means you are not just dealing with one person, you are dealing with two people, because you are dealing with your spouse and also dealing with a third party. These are things that affect your divorce, that affects the speed of your divorce. So we cannot just tell. I cannot start telling you, oh, on this ground, on that ground. If you coming up and you're proving adultery, you proving emotional abuse, you're stating emotional abuse, you're stating adultery, you're stating neglect, you're stating physical abuse, you'll be required to prove it. You'll be required to show it. And this can cause significant delay to your case. Now, let's go further and let's see. Another thing that can determine the speed of your divorce is if, for example, the divorce is contested. right? If the divorce is contested, maybe perhaps in your divorce, you are trying to say, oh, my spouse did this, my spouse did that, so I'm divorcing my spouse. And your spouse comes to contest it to say, no, I never did that, by way of reply, right? Filing a reply. Or your spouse decides to cross petition to say, hey, guy, you're not the one who is supposed to be in court for divorce. I'm the one that is supposed to be in court for divorce. In fact, now that I'm doing this live and you're enjoying this live, I have a particular brief on my desk, right? So the man petitioned for divorce, and by the time my client is done with her own story for us to prepare her reply, she goes through her husband's divorce petition. She says, no, she wants to cross petition, right? So you can decide to cross petition. That means if we are cross petitioning, it means we have like technically 2 cases before the court, although it is 1 case, right? So it means you are saying, no, you are not the one who has the right, I'm the one that has the right. You don't have better grounds, I have better grounds. You shouldn't be the one asking for this. I should be the one asking for this based on how you have treated me all these years, right? So this, if it's contested, it means that we are literally fighting. Okay. No, we're not literally fighting. It's not a physical fight, but in reality, we are fighting, right? And you know, when it comes to fight, many times people always fight dirty when it comes to divorce. And that's what makes family matters, family law matters, divorce actually very emotionally demanding for those of us who are family law practitioners or those of us who are divorce practitioners. Because the couple may decide to start fighting dirty and you're like, why do you have to do this? Of course, people want to prove their case and they want to prove their hurts. They want to prove their displeasure, so they will always usually go all out, and this can cause significant delay. So you want to ask yourself, is your divorce contested? Okay, now you could also want to ask yourself, because this is also something that determines whether your divorce would stay long in court or will not stay long in court. If it is uncontested, trust me, if it is uncontested, you are blessed. It means that your spouse is refusing to reply, or even if your spouse replies, the two of you during the compulsory conference, right? During the compulsory conference, you are able to settle all the issues arising, and now the court only just needs to take evidence as regards the dissolution. I have done a case recently like that in the same month, right? In the same month, during the compulsory conference, both parties decided to reconcile about the auxiliary matters, reconcile about issues regarding their child, right, which is the issue of the marriage. And now the court is just left with the dissolution to address, because in reality, as against what you have seen on African Magic, against what you have seen on Nollywood and what you see on social media, you can actually not settle to divorce in Nigeria. In the sense, let me say it clearly. I want to say it clearly again, that you cannot just decide to, both of you come, write letters, reach agreement, and you have divorce. No. Most of the time, what is required by law is that you will definitely go to court. And the petitioner in many courts in Nigeria will have to enter the witness box and give oral evidence to support the divorce petition, to support the claims, to support the grounds for the divorce, right? So even if the two parties, so if one person files a divorce petition and is served on the other person, and the two people come together and say, oh, let's see how we can settle and let's see how we can resolve issues. When they agree to resolve these issues and the rest, and they agree to say, oh, we are still divorcing, we are still going our separate ways, they will still have to come to court, file that their terms of settlement or report of compulsory conference, and the petitioner will still be required to give oral evidence. So you will still have to follow that process as it were. So forget all those Nollywood where you hear people say, I will not sign the divorce papers. We usually laugh when we say that. We don't require you to sign any papers. In fact, if you don't show up in court at all, it makes our case better. It makes our case easier, because once the counsel, once the lawyer told the petitioner can prove that you have been served the court processes, you have been adequately served the court hearing notices, and you refuse to show up and you refuse to enter the case you refuse to file a reply, it is assumed that you agree with everything the petitioner says and you have no defense and you have no opposition. You are not contesting it. So when you refuse to accept court processes from court bailiffs or from whichever means you accept, and you refuse to brief a lawyer to enter a reply for you or to enter an appearance for you, you are making the case of the petitioner easier. It is so easier to divorce you. In this year, I've also had to attend to a matter like that, in which the spouse refused to accept court processes, refused to show up in court, and why that person today is arguing that their marriage is still existing, their marriage is still subsisting, by law, the marriage has been dissolved. So I had to make it clear to my clients that, see, forget everything you may have seen from Nollywood. Forget everything you hear out there. It does not apply like that in real life. So if it is uncontested, in the sense that if your partner is not contesting the divorce, it makes it very fast. Now, there's something else that also significantly affects how fast your divorce would be. It has to do with the court's case load. I will explain this. The court case load. There are many courts in Nigeria, or I'll safely say most of the courts in Nigeria, they have so much workload that many of us who are at the bar, we are scared of becoming judges. Like, if you tell me, hey, all right, do you ever wish to become a judge? I will tell you why. Why should a judge be handling 30 cases in a day? And he's going to do that every day of the week. The average cost list of a judge every day, I doubt in any court in Nigeria, may be less than 20. I doubt if it's less than 20. Unless maybe the person is a new judge and so the person is still going through the orientation processes, so they don't want to bombard the person with lots of cases. But the average I have seen in courts, the courts that I go to are usually 20 and above. So if a court has more than 20 cases in a day to handle, and this court will start sitting by 9 a.m., the judge uses long hands to take notes. The air conditioning of the courtroom is bad. The furniture of the courtroom is bad. The system is bad. Nigeria generally is stressful and demanding. Where do you want that judge to have the physical energy, the emotional energy, and the psychological well-being to be able to actually handle all those cases in a day? Mind you, he's going to go through longhand, writing his orders, writing his rulings, writing his judgments. So what is going to happen is that a matter that a judge ordinarily will be able to take in a day, he may not have to take adjournments, so that he has sufficient time to be able to attend to other cases on his course list. Imagine handling 30 cases. The judge will start sitting by 2 p.m. We know this judge has to start sitting by 9 a.m. And we know this judge has to rise. He just has to rise not later than 1 p.m. because he will still have to write rulings, write judgments, review cases, write orders before 4 p.m., which is his closing time. So it is advisable that he stops sitting by 1 p.m. so that he has 3 hours to take a lunch break and attend to other matters, and also read the case files for the next day's sitting. So they will always adjourn, regularly adjourn. The workload of the courts determines significantly how long your case will last. This is why you will notice that for many family lawyers, for many divorce lawyers, will always want to take your divorce cases, especially if you are in a hurry, will always want to take your divorce cases to remote villages where we believe that these judges, their course list, their registry is not filled up with pending cases. But again, there are also other things that will also factor, which is different from the fact that the course load is full. The court's hand is full. Another thing that also affects in this case is when it comes to holidays and other acts of government. So we'll look at acts of God and we'll look at acts of government. Take, for example, if your judge is sick, your judge will not be able to appear in court. But let's come back. Let's assume a judge has 30 cases to handle every day. And the average judge in Nigeria has more than 500 cases to handle. In some places, there are actually about 1,000 cases to handle, the average judge. Of course, our judiciary, they are short staff. We have shorthand on the bench. We don't have as many judges as we ought to. And our political class are not doing anything about it. They don't care. They don't care about you. So a court, a state that is supposed to have the minimum of, let's say, 60 judges may not even have up to 25. So 25 judges will be doing the work of about 60 judges. So you are seeing one local government that may have more than 5 kingdoms having one high court. Yes. Take, for example, my local government where I come from. We just had a high court not too long ago. Is it up to 10 years? It's not up to 10 years that we had a high court in my local government. And my local government has Eastern Central. Eastern Central has Ira, has Ehu, Ubegun, Opoji. Right? And about 5 kingdoms, yes, there's also another community now I cannot remember. And I'm talking about kingdoms. I'm not talking about clans. I'm not talking about villages. I'm talking about kingdoms. Right? And it's just recently, not up to 10 years, that we had a high court. So all the matters from that particular local government will usually go to another local government's high court. A local government having only one high court. So imagine that this judge has maybe 500 to 1,000 cases and he has to attend to 30 every day. 30 every day. So if it's to go through a circle and he has 1,000 cases, if he starts your case today and your case is number 1, imagine how long it will take you to go through 1,000 and come back to your case. If it's to go through a circle. Now, in going through this circle, we have what we call acts of God, and we have what we call acts of government, and we have what we call acts of community, acts of society. What's the act of God? Number 1 is the fact that your judge may be sick on the particular day that your matter is supposed to come up, and he cannot show up in court to sit over your case. You have to take an adjournment. If you go through that circle, your adjournment may have to be in the next 3 months, 4 months, 5 months. That's the act of God. That's an act of God, for example. Then there's the act of government. The act of government is, for example, public holidays. When there are public holidays, your case falls on the public holiday, or maybe there's an act of community. Maybe there's conflicts, there's protests, there's all of that. There are administrative things that the judge needs to attend to. There's a conference the judge needs to attend to. Right? These things can also cause delay. In fact, take for example, there could also be another one that maybe your judge has been assigned to become a member of a panel in an election petition or something else, and so the judge is not even available to sit on your case. I remember right now one of the cases I still have in court. I am for the respondent. The petitioner filed that petition in December 2022. December 2022 was when they filed that petition. I filed the reply on behalf of my client in the first week of January 2023. The first time that matter ever came up in court, I mean, the first time the judge was available to sit in our case was in May 2024. So for about 1 year, 6 months, that matter was just pending in the registry. Right? It was just pending in the registry. We just kept on taking dates, because for any day the matter is coming up, it's either the judge has an administrative task, or he's on a national assignment, or something is keeping him away. There's a public holiday and all of that. Then another thing that matters that will also cause delay in your case is the availability of evidence and the availability of witnesses, especially when you are needed to prove certain things. I have seen people who want to prove adultery and they are unable to provide the pictures. They are unable to serve the other party to get the other party joined in court, and that party is required. it's mandatory that that party is join the court, right? So they are unable to produce the things that they need. For example, a man says, I'll be the one paying my children's school fees and I'll be the one paying my children's house rent. And the wife says that's not true. And now the man needs to produce all his receipts. He needs to produce all the evidence. So he needs to go to court and he needs to get the statements, all the different things, right? Sometimes your witnesses may be people or police officers who witnessed or documented domestic violence, documented abuse, and you need to get them in court. And for example, your IPO has now been transferred to another state or he's on a national assignment somewhere, right? These are things that could actually cause delay. Mind you, like I said earlier on, the nature of your case, the grounds for your divorce, the particular court where you are filing this divorce, all contribute significantly to how fast your divorce case would be. Another thing again that causes it, unfortunately, that may cause delay or speed in your divorce case has to do with your lawyers. Who are your lawyers? There are some lawyers who are lazy, unfortunately. Then some lawyers don't, or they may not feel motivated based on your fees and how you down price them. So there's no motivation for their case. So they will always want to give excuse not to attend to your case if they have a better case to attend on the same day, right? Or they have other things to attend to. Perhaps they are supposed to file ABC today, and now you have not paid them. They will cause a delay. They will not file it. They will definitely not file it because the assumption is that if they file it, you are most likely not going to pay them. Recovering their fees will take another procedure, another legal process that they don't want to go into. So that is one way. Your lawyer could also be sick. Your lawyer could be traveling and have an accident. Your lawyer could have another family matter that is more important than his job at that particular time, and he will ask for an adjournment. There are different ways lawyers could also, your lawyer could also cause some delay. For us in our firm, we try everything possible not to be the reason why a client's matter is delayed. And that is why we usually tell you that, see, you see this, your fees, it ensures that there's always a lawyer in court to represent your interests, and it's always to ensure that there is never a delay that is caused by your lawyer. So we ensure that in our law firm, we ensure that in our office, so that the blame for the delay or the slow pace of our client's case can never be us. Then there's also another thing again, which is procedural compliance, right? You can't take that away. I will give you one case I'm handling as an example. This couple, they wanted their divorce, and they wanted their divorce as fast as possible. I talked with both parties. We agreed that, see, they should go their separate ways because they were not willing to work on their marriage. They wanted the marriage to end by all means. They wanted the marriage to end by all costs. But then there is a procedure in doing divorce. Now, their marriage was less than 2 years, which means that the law required that we needed to first of all seek the court's order. We needed to seek the leave of court to even file the petition, right? So we had to first of all go through that. After that, before we started filing the petition, now that we have filed the petition, the respondent has certain number of days given to him to respond. See, even if you respond in a shorter period, we will still have to come and apply for the matter to be set down for hearing. Matter set down for hearing. And the next thing I was hearing was that the registry asked me that I should write a letter for a date to be assigned to the case. So there are procedures that could also cause delay as to the time required. Take, for example, let's assume you wanted to remarry, or you wanted to travel abroad, or you wanted to file a particular document as a divorcee. The law says that from the day you get judgment on your divorce, from the day your divorce is granted, to the day you can remarry, to the day absolute, it's actually 3 months. Right? So you need about 90 days for you to actually say, oh, I'm fully divorced right now, I can start filing divorcee, I can remarry. So there's sometimes it is the procedure. So no matter how much you want to rush things, the law says this thing has to take 10 days, this thing has to take 20 days, this thing has to take 5 days, this thing has to, like a motion will only be mature in 5 days, a motion notice, right? So these things have to do all of that. There's also the place of court efficiency. Court efficiency is the fact that because our courts are not fully automated, they are not digitalized yet, it's still the manual processes, many court staff usually may not be so efficient in making things happen a lot. And then also the judges get affected, because if the judge has to do long handwriting, his head, that of his wrist, and convenience would also play. There's also another thing that I may have skipped at the beginning that I want to mention now. There are times that judges, their holidays, like right now, this is June, by second week of July, High Court judges would go on their annual vacation. They are most likely not going to return until the second week of September during the new legal year. So it means that if you file a case today, if you file a case, or rather, this is already in the night, if you file a case tomorrow morning, which is Wednesday, and it's a divorce matter, it may most likely not come up in court until October. Let's look at November to be safe. Right? Because there is a vacation period. From the vacation period, there's the new legal year celebration period that will come in before the judges will be able to start attending to regular matters again. Now, can a divorce be an emergency? Well, in my 13 years of experience as a family lawyer, I have not seen a situation where a divorce was actually an emergency. You may talk about the safety of the person, you may talk about the accommodation of the person, you may talk about the welfare of the person. These are ancillary matters that the court can attend to. So the court can give orders on this thing pending the final dissolution of the marriage. So the court can order that the couple be separated. The court can order that one person also pays maintenance and welfare over the children or over the other person pending the dissolution of the marriage. Right? So those things that are emergency, as it were, can be attended to by the court. But for the dissolution itself, no, dissolution itself, I have not seen a reason where the court regarded it as an emergency. They did not regard it as an emergency. I have not seen. There could be, but I have not seen. Right? Then there are also places where we come to judicial discretion that will determine how long. There are some judges that will just feel that, see, why are you in a hurry? Why are you rushing? Besides, you people are young. It's not like you just got married 1 year. You already wanted to come out. Why are you rushing? Why do you rush? Now, who do rush you, as Nigerians will say? The reason is because our legal system, our jurisprudence is pro-marriage and pro-family than pro-divorce. So as long as the court is concerned, the court will want to do everything to ensure that people don't divorce. We want people to go for counseling. We want people to see if you can talk to family members, talk to your religious leaders. We want you to do things to still consider if you guys can still be together. So judicial discretion, you may be in a hurry and the court will say, no, I don't want to. Let me give you an example of a judicial discretion. I had a particular matter and I asked for leave to file the divorce. And in the course of asking for leave, I attached the proposed divorce petition and I also filed it separately. However, the court, after granting me the order, refused to deem my separately filed divorce petition as properly filed and requested that I filed fresh copies, right? But there are some judges that will tell you that, okay, since you attached your proposed divorce petition to this application, and now I have also seen that you have filed separate fresh copies, I will deem those copies as being properly filed. But Landlord in this particular case said no, and I could not argue because it's the judicial discretion, and Landlord was right in making that order, was right in giving that directives. Then geographical location also matters. I mentioned earlier on how the court where you fight the case could also determine the speed based on the workload of that court. Then we also look at another thing that could cause delay is when it is contentious, and we are having to deal with children. We are having to deal with settlement of property, because in Nigeria we don't share property, we sell property. We settle property, not share, right? Now, when there is custody, the overriding interest is always that of the children. So this may take a long time for the court to settle. The court don't just grant orders when it comes to children. They sit down and ask themselves what will be in the best interest of the child when it comes to welfare, when it comes to custody, when it comes to the auxiliary matters that affect the child. So these are some of the things that determine how long your divorce would last in a Nigerian court. So in essence, your divorce could take 3 months, it could take 6 months, it could take 1 year. And I've seen somebody who said she did a divorce and it lasted about 7 years. It could actually take that long. I want to say right now that I have a particular matter, I have a particular divorce that has been in court for even more than 7 years. Yes, I have a divorce that has been in court for more than 7 years. In fact, in the last 5 years, we have not gone to court for that matter, thereabout. Why? Is that we have gone far in this particular court, and the respondent came up to say she can no longer be coming to that court, that court is too far for her, that she wants a court that is closer to her. And that court that is closer to her is not convenient for our client per se. Now, transferring the matter from this court to this court, my client has lost interest in the divorce, and he would just continue with the separation that he has always been having. And the rest. So there are cases that could stay that long, which would be, it could be that of the court, like the matter I had, that I said for about 1 year, 5 months, the matter did not even come up at all. Or rather, for every time the matter came up, there was always a reason for adjournment that was at the instant of the court. It was not based on us, it was not based on the other party, it was always based on the court. So we never appeared in that case. The court never sat on that case until after about 1 year, 6 months. So there are things that will cause delay based on court. There are things that will cause delay based on the nature of the divorce. There are things that will cause delay based on the parties. So that's more or less like it. How long will it take? I would say average, let's say 18 months. But most especially, ask your lawyer with the facts of my case and the intricacies of my case and the dynamics of my marriage. How long do you think? Your lawyer cannot specifically tell you, cannot categorically tell you, cannot emphatically tell you how long your case will stay. He can only just suggest that, if we do it in this court, based on this, based on this, based on that, hopefully by so and so time, we should be done with the divorce. And I say thank you for staying with me. Thank you for spending this time with me on Your Family Lawyer. Remember, I said again that the things that I share here do not amount to legal advice. It's just for educational and orientational purposes. Yes, I am a family law lawyer and also a divorce lawyer, and I've been doing this for about 13 years. And interestingly, I'm also a counseling psychologist, and I have been counseling for about 20 years. Yes, if you have any legal questions, you may want to drop it in the comment section or comment or send us a message with the details of this live. Or better still, you can find a lawyer that is closest to you. Thank you so much for joining me once again. Next week, Tuesday, by this same time, 7 p.m. Nigeria time, I will be discussing another topic with you. And from the ancient and modern city of Ibadan, where I live, I say you rock.